Liens, liens, liens. Yes, they're everywhere. You can't ignore them, and you can't wait until the case settles or until you're negotiating to get them. Been the bane of our existence for a lot of years. And at this point, there's really no excuse not to be on top of them. My name's Saul Gruber from Gruber Trial Consulting, and we help clients all over the country get their cases ready for trial. And one thing we tell everybody all the time is you must deal with Medicare liens, Medicaid liens, any other type of health insurance lien, and any type of military lien. You have to do it. You have to be on top of it. And there's never a reason not to do it. So what's the first thing we have to do? We have to understand who is paying our clients' bills, right? We need to know that from the get-go. Is it an automobile case, and do they have PIP? If it's a premises case, do they have health insurance? Is it Medicare or Medicaid? Is it a fully funded ERISA lien? Are they part of the military or union health insurance, which can assert a lien? You need to know this, and you find this out simply by talking to your client. But once you know, don't be bashful. Send the appropriate letters to everybody you need to deal with. The most common liens that we deal with, it seems to me, are Medicare and Medicaid. And they have made it so easy compared to 10 and 15 years ago. But the first thing you need to do is alert them that there is a case and what the case is about. You can do it very easily now through the portal, the CMS portal, which you sign up for and register for. And if you do any personal injury, you've got to be registered for the portal. It doesn't cost anything, and it gives you much more timely information. But remember, just because you alert somebody of a lien, I mean, they're going to be proactive in any way with you and keep you up to date on when the lien is getting larger and letting you know those things. No. That's your job. And how do you do that? Well, you can put it on a diary, obviously, and every so days contact them. But really, what you need to do is ask for a conditional payment log. And when you get that, review that log, and that speaks for itself. It gives us all of the bills that Medicare paid that they claim are due to the accident that you told them about. Well, there's a very easy appeal process you can take. It's much easier than it was, again, 10 or 15 years ago. Do it. Review the log when you get them. And just because you get a conditional payment log in January doesn't mean it's the same exact payments that are going to be around December of that same year. So once the case is getting closer to negotiating, get another one. Now, that's particularly important in cases with continued treatment, such as motor vehicle cases, premises cases. A little less important, but you still do it in a nursing home case or a medical malpractice case or any other wrongful death case where the treatment pretty much stops. But you want to do it again when the negotiation starts. And now you have that number you can begin to negotiate with. When you do, just keep in mind and remember that the payment is not going to be that number, right? At least when it comes to Medicare and Medicaid. They will reduce that number per statute, and they give you the formula to do it. It's not really hard. It's basically reducing as if you would on your disbursement sheet. But you want to keep that in mind, because once you're about to settle the case, you then get the final payment, a lien. That's right. You don't know the final lien until you report a settlement. How crazy is that? But that's why it's important to really keep up to date on the conditional payment lien, right? That log, because if there's more bills than are included in there, you want to know that before you settle the case. But either way, you have to be aware of the lien and all the rules of the lien, such as if it's an ERISA carrier based insurance lien, they don't reduce that lien. You're going to have to repay the entire amount, and they don't play games. But you have to make sure that it's a fully funded ERISA lien, because that's where there's issues. So you want to make sure that all of the items that make it a fully reimbursable lien are actually met. Same thing with a military lien. Believe it or not, the rules about the military are a little bit different. Same thing with a union lien. Whatever the lien is, whoever the health insurance carrier is, make sure you understand what's supposed to happen, you do what you're supposed to do to get all of the right information, and you protect the lien. Because guess what? If you don't protect the lien and you settle the case and that lien is outstanding, I want you to guess who the government is going to come after. And the cases are clear. It's you. Again, it's that important. The worst thing you could do is when you're negotiating right before a trial is say something like, I have to find out what the lien is, Judge. You need to know what the lien is. There's no excuse not to. Don't wait till the last minute. Get on it right away, and you'll protect your client. My name is Saul Gruber from Gruber Trial Consulting. If you have any questions about litigation, give us a call. We're here to help.